So you want to know about sexual harassment. Well, you're in luck. I'm an employment lawyer, and in this video, I'm going to talk about how the law defines sexual harassment at work. By the end of this video, you will know at what point lewd comments or conduct constitutes illegal sexual harassment. So stick around. Nothing in this video is legal advice. If you have questions about sexual harassment at work, talk to a lawyer in your jurisdiction. If you're in Washington, you can contact my office for a free consultation. Second, because I'm licensed in Washington, I will be talking about the laws of Washington state. But these laws are very similar to the laws of most states. So if you hear anything in this video that sounds like it might apply to you, it probably does. So make sure to talk to a lawyer. Okay, let's get started. To understand the law against sexual harassment, we have to begin by looking at the law. In Washington state, the law against sexual harassment can be found within the law against discrimination. Specifically, we will be looking at RCW 49.60.180 subsection 3, and I'll put that law over here. That law states that it's an unfair employment practice to discriminate against any person in compensation or in other terms or conditions of employment because of sex. So what does the law against discrimination have to do with sexual harassment? Well, you see, sexual harassment only happens because of sex. It's a form of discrimination. So the law against discrimination is also the law against sexual harassment. But to qualify as discrimination, the sexual harassment has to meet a couple of criteria, which we will get into. But before we get into those criteria, let's first talk about the different kinds of discrimination, because the criteria under the law is a little bit different for each. So under the law, sexual harassment falls under one of two categories. First, we have hostile work environment sexual harassment. And second, we have quid pro quo sexual harassment. Let's look a little closer at each. Hostile work environment sexual harassment is the most common type of sexual harassment. In this video, I'm going to go over briefly the elements of a hostile work environment sexual harassment claim, but if you want a more in-depth look at hostile work environment, check out my video on workplace harassment. I'll put a link to that video in the top right corner of this video right now. Hostile work environment sexual harassment occurs when a harasser subjects an employee to unwelcome sexual conduct or comments that are so severe or pervasive that it alters the worker's conditions of employment. I'll put those elements up here. Unwelcome simply means that the worker didn't incite the conduct or comments, and that the worker found those comments or conduct offensive. Severe or pervasive means that the conduct or comments were either extreme, like touching or threatening, or the conduct or comments were persistent over a period of time, over and over again. Altering a worker's conditions of employment means that the comments or conduct made the worker's job more difficult to do. Maybe the worker had to change positions, or the worker had to change placement in the company, or the worker had to take lunch off-site, or use a different entrance or exit to get to their job. Finally, the employer is liable for the sexual harassment if it knew or should have known about the sexual harassment and failed to take prompt and adequate corrective action. An employer knows or should know about the sexual harassment if the worker complained to HR. An employer automatically knows about the sexual harassment if a manager is the harasser. Once the employer knows or should know about the sexual harassment, the employer then has an affirmative duty to take prompt corrective action to remedy the sexual harassment and prevent it from reoccurring. If the employer fails to take any corrective action, then the employer is liable for the sexual harassment. The other form of sexual harassment is called quid pro quo sexual harassment. Quid pro quo is a Latin term meaning something for something. Quid pro quo sexual harassment occurs when a manager or supervisor subjects a worker to unwelcome sexual conduct or advances and expressly or implicitly promises to change the worker's status if the worker submits to the advances. The promise to change the worker's status could be a benefit or a lack of detriment. For example, a manager might tell a worker that if she dates him, she'll get a raise. That's quid pro quo sexual harassment. But alternatively, a manager might tell a worker that if she dates him, she can keep her job or she won't get fired. That is also quid pro quo sexual harassment. Okay, so now you know what sexual harassment is under the law. But what happens when you win your claim of sexual harassment? Well, you can get damages. Under Washington's law against discrimination, victims of sexual harassment can collect their actual damages. Actual damages are things like emotional distress and lost wages. Lost wages are available when you are fired or you have to quit your job because of the sexual harassment. Lost wages are the wages you would have been paid if you remained in that position. And lost wages don't end when you file your claim. If you take a position that pays less, or you don't take any position at all, you can receive future lost wages, known as front pay. And emotional distress damages seek to remedy the emotional harms the victim had to endure. For instance, any embarrassment, humiliation, loss of enjoyment in life. Victims of sexual harassment can collect monetary compensation to offset those emotional harms. Okay, so now you know what constitutes illegal sexual harassment at work. Sexual harassment under the law can be either a hostile work environment or quid pro quo sexual harassment. Hostile work environments occur when a worker is subjected to unwelcome sexual comments or conduct that are so severe or pervasive that it alters the worker's terms or conditions of employment. Quid pro quo sexual harassment occurs when a manager or supervisor seeks a sexual favor from a worker in exchange for a job benefit or lack of job detriment. If you live in Washington State and think you are a victim of sexual harassment at work, feel free to contact my office for a free consultation. And share this video with other workers so that they know what options are available to them. The more we hold employers accountable for their wrongdoing, the more we protect other workers. Okay, that's all for me this week. See you next time.